There was a moment of stillness in the room, and I let it pass, but now I'd like to reclaim it. Good morning, everyone. I'm David Levy. I'm the new dean of the Duke Law School. I'm pleased to welcome you here to Duke, to this wonderful setting for this very important conference. We are delighted, truly delighted, to have joined with the American Bar Association in assembling such a distinguished group of scholars, scientists, citizens, activists, regulators, students, and lawyers to discuss, to debate, and to study significant issues in animal law and bioengineering. This is the first conference jointly held at the Duke Law School with the American Bar Association, and we are very glad to have this relationship with the ABA. May it continue, and may there be other opportunities in the future for such collaboration. In addition to the American Bar Association, there are many others who should be thanked. The funding for this conference has been drawn from the endowment created by Bob Barker here at the Duke Law School for the study of animal law, and from the following sponsors of this conference: the Animal Legal Defense Fund, the North Carolina Association for Biomedical Research, the law firm of Womble, Carlisle, Sandridge, and Rice, and the law firm of Covington and Burling. Thank you very much. Thank you to our sponsors. Of course, I should thank Professor Bill Reppy here, who is known to you all and who is one of the leading figures in this area of the law and has done so much with others to bring this conference to fruition. Thank you, Bill. This conference is the first major conference built on a dialogue among scholars of animal law, activists who advocate for animal rights and are seeking reform in animal welfare laws, scientists who use animals in their research, and the regulators and the attorneys who work with these scientists. Our participants come from the United States, primarily, but also from Canada. Our expectation is that this convening of minds and different viewpoints will at least lead to the clarification of some of the disputes. And we hope that the discussion may take us even further to identify areas of possible agreement, new public policies, new insights, and new areas for scholarship and for research. The conference is further evidence of the major commitment that Duke Law School has made to the field of animal law, and I commend to you the symposium issue of our Journal of Law and Contemporary Problems that is devoted entirely to this topic. This conference is also the example of the kind of work that we think that Duke Law School does particularly well, which is to attempt to bridge whatever divide there may be between the academy and the professions, between the worlds of theory and scholarship and the worlds of practice and public policy. We try to, and do here today, bring together those who work in a diverse range of fields, in the professions, in government, in the judiciary, and in the academy, and not just here in the United States, but also, as I have said, in Canada, and therefore in other countries. So again, it's my very great pleasure to welcome you to Duke Law School. I am sure that this will be a very productive 2 days, and thank you all very much for being here. Welcome. Thank you.
I'm Jill Mariani. I'm the chair of the Animal Law Committee of the Tort Trial and Insurance Practice section of the American Bar Association, which I will refer to as TIPS from then on. And I think that the dean has eloquently told you why this is going to be a groundbreaking program, why we are in a position now to actually have an opportunity to dialogue in a scholarly and respectful way with those whose perspectives we think are different from ours. But I've come to realize in the last several months that we have a lot in common. I thank particularly Professor Reppy, the Dean, and the Law School for all their assistance in putting this program together, this wonderful campus. Although I'll have to tell you the weather, I brought that from New York. That is our beautiful crisp weather that I brought down with us. I recall that it was about 7 or 8 months ago that I encountered Ellen Flannery in the hall of one of the hotels while we were doing the mid-year meeting for the American Bar Association, and posed to her the idea of putting together a program with science and technology. And Ellen, who is quite an amazing person, looked at me first with a kind of a quizzical look, and then with a very open-mindedness said that she'd explore it. And then I understand that Gil Whitmore, the current chair who's going to be here of Science and Technology, was very supportive and said, give it a go. And so they put together for our staff from the Animal Law Committee and Duke, 3 amazing, stellar people who months ago I would not even have thought that I had anything in common with, let alone the opportunity to talk with, which is just a forerunner of how this is going to be very groundbreaking, that we are now going to be dialoguing and befriending people of a different discipline. And so I had the opportunity to work with scientist Barb Glenn, who's going to be a speaker, scientist Deborah Runkle, who's going to be a moderator, and veterinarian and lawyer Jeannie Perrin, who's going to be a speaker. And I realized that in many respects we have a common goal. There are common areas where science and those who care for the humane treatment of animals really get to an end goal that they have in common. We get there different ways, and there may be very creative ways in which we can get there together. I was also very inspired by the fact that the Special Committee on Bioethics was interested in co-sponsoring this, and when we had the support of Judge Carol Lee Novell through some of our colleagues, and the current chair, Ellen Rosenblum, of that committee, I realized that the leadership of the bar that has supported this demands that we really do a good program here, that they have such confidence in us. And those of you who are students or who are not from the American Bar Association may think that these are names that I'm reading off like it's, you know, the Academy Awards where you say thank you for all these people. But these are very high-level leaders who see the value of what we're doing. I also want to take one moment, please, to let me bask in the support of my American law, my Animal Law Committee and the TIPS leadership. It is such a privilege that we have the support of our section. Everybody at TIPS has been known to say, oh, our staff is the best in the ABA, and they went well and beyond the call of duty in this case, particularly Deborah Wetzel and Nick Michna. My colleagues in other committees have been so supportive. We have co-chairs from 2 other committees, Natalie Vermette from the Intellectual Law Committee, who is going to be a moderator, David Furlow, who's also going to be a moderator from the Media, I always get it wrong, it's Defamation, Media, and Privacy Law Committee, who I've got to regard as my friends and not just my colleagues. We have leadership here from the American Law the Animal Law Committee that goes back to our beginning. Our founder, Barbara Gisselson, who's going to be a moderator today. Our predecessor, Christina Hancock, who's also a co-organizer. Our David Favor, who has spent over 20 years in this area of practice, our vice chair and a co-organizer. We have our student vice chair, who's coming from Miami. Our membership leader, who is here, Marion McDermott. The amazing support is just overwhelming. But we would not be here if it weren't for one man. And that's our section chair, Peter Bennett, and I have the privilege of introducing him. And the reason we would not be here is because when we were just like almost 2 years old, he said to somebody, you should do a national program. And you would probably think that coming from a leader in TIPS, that would be an interesting or whimsical suggestion. However, I didn't know then that much about Peter because I hadn't been in the section that long, but I realized that he is not only a man of vision, but a leader who's ahead of the issues. And that was exemplified by the wonderful program he did at our fall meeting on the independence of the judiciary, which was really ahead of the curve. So what Peter was really saying to all of us was, here's a challenge and an opportunity. And I hope, Peter, that we've risen to that challenge and opportunity, because now, having celebrated our 4th anniversary just a month ago and going into our 4th year, we are now putting together what the Dean has so eloquently described as a first of its kind conference, not only in who we partner with, but in what we have to say. And with that, I would like you to give us a warm welcome to our section chair, Peter Bennett.
Thank you, Jill. I'm not quite sure that was earned or deserved, and hopefully other crazy thoughts won't come out of my mouth as I give this introduction. But when our section started its Animal Law Committee, I met Barb Gislis, and she came. I'm from Portland, Maine, and she came. We had a meeting in Maine, first time our section ever met there, and we really weren't sure what to expect and had decided as a group, our governing board called our council, had decided as a group that we would give her the courtesy we would extend to any other lawyer who had an idea to create a committee. Although most of us were extremely skeptical of the subject matter and of the agenda. And this woman came in and made a presentation in Maine that was so compelling that our section embraced the topic of animal law and created the first national committee within an organized national bar association dedicated to the subject. And over the last several years, the work that's been done by Barb and then Christina and now Jill has been incredibly groundbreaking and frankly is one of two or three really bright shining stars of the tort trial and insurance practice section. And I don't get credit for that, and I really don't get credit for this idea, but you were kind to say that. But let me spend a few minutes talking about two other subjects that have indirectly something to do with today's program, but not a lot. First, let me tell you about the tort trial and insurance practice section. We're one of the largest sections in the American Bar Association. We have over 35,000 members. We're also one of the oldest. This is our 75th anniversary. And other than animal law, we cover 34, actually 33 in addition to animal law, substantive legal topics, from appellate advocacy to trial practice to automobile law to employment law to intellectual property to defamation. Basically anything that somehow ties to either a courtroom or to liability or insurance is within the scope of our mission. We're very dynamic. I actually was one of the people instrumental for the law students in this room, instrumental in getting law students involved not only in our section but in the ABA. There's always been a law student division, but it's always functioned off on its own, and our section has worked very hard not only to have law students as members, but law students as leaders. And if any of you who are students have interest in becoming involved at the ABA level, we have opportunities for you, and I'd invite you to come talk to me during a break and give me your contact information, because even if it's something like writing case notes for newsletters or for magazines, there are opportunities that will introduce you to bar leaders and that will give you networking opportunities that may take you much further than you think, especially as you consider your career and go forward. But what I'd really like to talk about today for a few minutes is something and sort of related to this conference, but sort of not, and that's the rule of law. The reason I want to talk about the rule of law is that the rule of law makes a conference like this possible. We tend in this world to take the rule of law for granted, not in the world but in this country. We tend often to take it for granted, and it's very important because it allows an informed debate like we're going to have over the next 2 days that will ultimately shape public policy and perhaps result in legal change to take place. The rule of law touches our lives in infinite numbers of ways. Traffic lights, we obey traffic lights in this country. We obey tax laws. We do all kinds of things that we more or less take for granted. But there are opportunities in extreme ways where the rule of law steps up and makes a difference. And I'm going to tie this to current events, which is why I want to talk about this. But about 3 months ago, a judge in Boston, Nancy Gertner, issued a decision in a case brought against the United States government and really brought against the Federal Bureau of Investigation, and awarded to 2 men who are still living and 2 men who are deceased in excess of $100 million in damages because these 4 men were convicted in the 1960s of committing a murder that they did not commit. And the FBI agents who were involved in this happened in Boston, and there's a movie being made about this, so you'll, about 2 years from now, get to see Spielberg's movie. But these men were wrongfully convicted because certain dirty agents in the FBI were trying to protect certain people who were part of the mob while they were trying to sort out a battle between the what I'll call the Irish Mafia and the Italian Mafia. But they allowed evidence to be covered up and knowingly let these 4 men all be sent away for life without parole terms in prison. And Judge Gertner had the courage to believe in the rule of law and uphold the rule of law and hold our government accountable. The lawyer who spearheaded this was a man named Victor Garrow. Victor's a small-town lawyer who practices in the suburbs of Boston. And he met one of these men while he was in prison, a man named Joseph Salvati, who told him or convinced him that he had been framed and had been sent away for life, and it was absolutely a miscarriage of justice. And Victor Garrow is a lawyer, and we can be proud of this, spent over 24,000 hours of pro bono time over 25 years proving the innocence of his client, not because he was going to get paid for doing it, but because as lawyers it was the right thing to do, and it showed his respect for the rule of law. This happened within the lifetimes of the majority of the people in this room, that we could have a government that had people in it who would throw the rule of law under the bus for some other purpose. And it's only through having lawyers who adhere to the rule of law and judges who adhere to the rule of law that our country continues to set the standard that the rest of the world envies. I tell you this story because of current events. And the current events I want to talk about for a moment, and then I'll be done, are current events in Pakistan, where the rule of law apparently has been suspended, where President General Musharraf, if you haven't followed the news closely, fired his Supreme Court, and you'll be hearing from a Canadian Supreme Court justice while he's here if you get a chance to talk to him. I think it'd be interesting to hear his thoughts on a president who can just shut down the courts and fire them, placed the country's judges under house arrest, has jailed in excess of 3,000 lawyers who have tried to protect the rule of law, and at least anecdotally I've been told has offered the police or whoever allegedly enforces the law in Pakistan extra pay to get those lawyers who are out there saying things, enforced a blackout on the media to prevent much of this from getting out. But it's only because of the rule of law that we need to talk about this and appreciate how close to home this really hits, because it's a generation ago that other miscarriages took place in our country, and since then those things continue, and it's only as lawyers stepping up to the plate and speaking out and trying to make a difference that the rule of law is important. In our country, the rule of law remains under attack in different ways, and Jill was kind enough to mention my judicial independence program. But the judiciary in our country is facing unprecedented attack, some of it very subtle, some of it not. But in terms of violence that arises in either courthouses or against judges and their families, in terms of the politics that has affected the judicial process, and the politics sometimes finds its way onto the TV news and other times into political campaigns. And political campaigns are fine, but fundraising has reached epic proportion, and it's not just in-state political fundraising, it's out-of-state money that affects these things. There's a lot going on that we as lawyers need to step up and try to protect. And as you sit here over the next 2 days, obviously you're here to learn about animal law and bioengineering, but appreciate the role that the rule of law makes in allowing conferences like this to take place. I hope you have a great 2 days. Thank you for listening to me, and have a great time.
Good morning. My name is Barbara Gislason, and I'm so pleased to see you all. I'm going to do very quick introductions to two outstanding panelists, and I'll introduce them in order when they speak. The first one is Betty Goldentyer. She is a graduate of Boston University, the Tufts Veterinary School. She has a background in private practice in Chicago. She worked for Humane Society there. She's been a field inspector with regard to exhibitors, dealers, research laboratories. She has, since 1988, served as the Eastern Regional Director of the United States Department of Commerce, and that's located locally at the North Carolina State Regional Centennial Campus. And she has a bearded dragon named Zai. Welcome.
Thanks. Okay, thanks, Barbara. And just one little correction, it's the Department of Agriculture. So as I talk through about the department, it's the USDA. And I really appreciate the opportunity to start your conference off with a brief history of the Animal Welfare Act from the regulator's perspective. As I go through the changes that we've seen in the Animal Welfare Act over the last 40 years, I think you'll agree that it's been a really dynamic, quickly changing piece of legislation. And that's great because this is a very controversial area. Animal welfare, society's expectations for how we treat our animals have changed a lot over the last 40 years. I think you're also going to see during your seminar here the changes in the science, what we know about animals, how we use animals in biomedical research. There have been tremendous changes. So all that leads to changes in the Act, and that's good. For a regulator, that's hard. It's a challenge for us. We're always writing new regulations to keep up. We're always having to get the word out and train our inspectors, but it's been very rewarding to see the advancements. I'd like to start off with the Congressional Statement of Policy. This is the very first section of the Federal Animal Welfare Act, and this is the part where Congress tells us what they intend this act to do for us, and that is to ensure that animals intended for use in research, exhibition, and for pets, that's the commercial pet trade, are provided with humane care and treatment. The second intention for the Animal Welfare Act is to assure the humane treatment of animals during transport and commerce, and then last but not least, to protect animal owners from the theft of their animals by preventing the sale or the use of stolen pets in research. And keep those statements of policy in mind as we go through the amendments to the Act. Just a little background, a little grounding on how the Animal Welfare Act works. It's an administrative act. That means that the regulations and standards are promulgated under the Administrative Procedures Act. The authority under the Animal Welfare Act is limited to the U.S. and the territories. That means Puerto Rico and Guam and Samoa. The Animal Welfare Act is administered by the Department of Agriculture through a system of licensing and registration of businesses that use animals. So our commercial pet dealers and people who exhibit animals to the public, they get a license with the Department of Agriculture, and then they renew that license every year. research facilities and animal transporters register with us, and then they re-register every 3 years. So that's how we know who is using regulated animals. And then we ensure humane care and use through unannounced compliance inspections of all those types of facilities. The Animal Welfare Act provides for sanctions for noncompliance with the regulations and standards. The sanctions in the Act include civil penalties or monetary fines, also license suspension or revocation of license, and then there is a provision in the Act for referral to the Office of the Inspector General or the FBI if some kind of criminal penalty is warranted. Let's see. Did it go? There we go. Okay. I did want to mention that animal fighting ventures are prohibited under the Animal Welfare Act. And here's some of the subparagraphs that are in this provision of the Act. But I'm not going to go through that today. The APHIS, which is the Animal Plant Health Inspection Service, which is the division of USDA that enforces the Animal Welfare Act, we don't deal with animal fighting ventures. That goes to the FBI and the Inspector General. So when I go through the amendments to the Act, I'm not going to go into the animal fighting venture.
Is there a cow in the room?
Doesn't that sound like it? Yeah. Okay. Oops. I must be hitting this wrong somehow. There we go. Okay. Just cast your mind back to 1966. And The Sound of Music was the movie of the year, best movie of the year, and there's the Beatles. And in November of 1965, an article was published in Sports Illustrated magazine, Lost Pets That Stray to the Labs. Prior to this article being published, advocacy groups were lobbying Congress to pass some sort of federal animal welfare legislation. But then this article came out in Sports Illustrated, and then on the heels of that, in February of 1966, Life magazine publishes this article, Concentration Camps for Dogs. This article contains really graphic photos of terrible conditions and follows family pets stolen, lost, and ending up in these terrible dealer facilities and then on to the use in biomedical research. So that was really galvanized the public and was the catalyst for the Laboratory Animal Welfare Act of 1966, which was signed by President Lyndon Johnson in August of '66. The purpose of the Laboratory Animal Welfare Act was to provide humane care and use for dealers and animals that were being held for research. So very, very limited to these animals that were being used in research. And then the animals that were covered under the Act from the very beginning were dogs, cats, rabbits, guinea pigs, hamsters, and non-human primates. Now, based on that law, then the Department of Agriculture then promulgates minimum standards for licensing, who falls under this act, and then what are the minimum standards for the care of animals by these licensees, husbandry, veterinary care, what kind of record keeping we are going to require. A very key point is the record keeping requirements so that we can follow the animals through the system. I'm sorry. What do you think? Oh, maybe I need to point it over there. I just thought you might get a kick out of this. This is an ad from that 1966 Life magazine. And I just thought it kind of shows a little bit about how society's values have changed over the last 40 years. On the bottom it says diet with sugar for the fun of it. And there's a little endorsement from the National Research Council on sugar. When you go through these old magazines, you really realize it was a different world in '66. In 1970, that's Midnight Cowboy and Apollo 13, and the Animal Welfare Act is amended again. So 4 years later, amendment again, and a big one. Now all warm-blooded animals that are used in research are covered. So like you might think of ferrets or farm animals, that kind of thing. Now all warm-blooded animals are covered in research. The department is given the authority to inspect inside the research facility. So not just animals that are being held, but actually being used in research. A huge increase in mission area for the department is the inclusion of commercial breeders for the pet trade. And right from the very beginning of 1970, retail pet stores are excluded, but all the wholesale dealing into the pet trade comes under the Animal Welfare Act. And all the people who exhibit animals to the public, your circuses, zoos, movies, all the use of animals on exhibition falls under the Animal Welfare Act. And then regulations are promulgated in response to that. Okay. You wish you could just touch your computer. There we go. Okay. So 1976, this is the beginning of Apple Computer. And I think computers really changed a lot, as you're going to hear, a lot in science and also in our record keeping. And the act is expanded to include the use of animals in commercial transportation. Now this is a very critical time for animals when they are consigned to an airline or consigned to a trucking company and released from their owners and given over to a commercial transporter. It's very important that they receive humane care, and a lot of bad things had happened to animals during commercial transport. So now that gets included and airlines start becoming registered under the Act. The 76 amendments also include the imposition of fines for noncompliance at research facilities, and it requires that government research facilities comply with the provisions of the Act. Still today, the U.S. Department of Agriculture does not inspect other government facilities that are using animals in research, but they are required to comply. You might think of the Department of Defense. They use animals in research, the Veterans Administration, or the National Institutes of Health. So they also comply with the regulations. Whoop. Okay, well, I won't go back, but we're on to 1985, and the Silver Springs monkey case hits the public. It brings up, I think a speaker later in your conference is going to talk a little bit more about this, but there were many concerns raised by the Silver Springs monkey case about the use of animals actually in research by the investigators. And this was probably one of the main sparks for the Improved Standards for Lab Animals Act of 1985. And again, I know I'm on a theme here, but this was a huge change for us trying to regulate under the Act. The 85 amendments mandate IACUCs at the research facilities, and that stands for Institutional Animal Care and Use Committee. And this is an institutional body made of veterinarians and scientists within the research institution, along with an outside member to represent the community. And what the IACUC does is, prior to the use of animals in research, the IACUC reviews what the investigator intends to do to assure that the research is going to comply with all the minimum standards in the Act. That's a huge change. There were IACUCs prior to the 85 amendments, the Guide for the Care and Use of Animals, which was required Compliance with that was required for facilities that use public funds. They already used IACUCs, and what this 85 amendment did was make sure that everyone in the country who's using these animals in research is using the IACUC process for internal review prior to the use of animals. It required training for animal use and caretakers. This was a really good thing to add in, to make sure that when we're using animals in research, that everybody who's involved in that knows what they're doing. This is the first time that alternatives to pain and distress are required to be considered. If animals are going to experience pain or distress, we have to consider whether there's any other way to do that. Exercise for dogs and socialization. And environmental enhancement for the psychological well-being of primates. This is a recognition that there's more than just food and watering and space that's required to keep these animals happy and healthy. So these two provisions, exercise and psychological well-being, come into the Act. An annual inspection by the department of every research facility is included in the 85 amendments, as well as a very important resource for us and for all of you. The Animal Welfare Information Center is a division of the National Agricultural Library, and it includes lots and lots of information about animal welfare and is available to the public. Okay. Okay, 1990. So that was the 85 amendments, and they were big, and it took us until 1991 to even get the regulations promulgated based on the 85 amendments. But in the meantime, in 1990, we have another amendment. That's Nelson Mandela and Driving Miss Daisy. And the 1990 amendments call for a tightening of the regulations to help prevent the sale or use of stolen animals. So it brings in a 5-day holding period, which is to allow people to be reunited if they've lost their pet, and it requires informed consent. So if an owner is releasing their animal to someone else, that they have to say they know, they're aware that that animal might be used in biomedical research. Then it's kind of quiet for about 12 years. And there's the Enron scandal and the Helms Amendment of 2002. A little bit of background on this. From the beginning, when the Department of Agriculture started looking at animals that are used in research, rats, mice, and birds were excluded. And the reason that they were excluded from coverage under the Act was twofold. First of all, there was already a lot of regulation under, as I mentioned before, the Public Health Service and NIH, so they already were protecting animals in facilities that got federal funding. In addition, this is a huge, huge number of animals. 85–90% of the animals used in research are rats and mice, and the department was just not funded at the level that could handle something like that. So by regulation, the department excluded rats, mice, and birds. There was questions were raised about whether or not that the department had the authority to even do that. After consideration, the Department of Agriculture decided, well, maybe we don't. Maybe we need to look into whether or not we should be covering rats, mice, and birds used in research. At that point, Congress, with this Helms Amendment in 2002, told us no. Those animals are going to be exempted by law from the provisions of the Animal Welfare Act. So it was a big, important amendment, but nothing really changed from the regulator's point of view. And now what I'd like to do is switch gears just a little bit and talk about a policy. When we have a change in the science, in our understanding of what animals need, in social expectations, we sometimes have to make a decision or an interpretation of the regulations that's not really spelled out. And the way we do this is we develop some policies that helps us inform our stakeholders and inform the animal users and helps our inspectors do this in a uniform way. These policies do not have the weight of law. They're not even regulation. They're just guidance documents only. But they are very useful to us, and they, in the past, had not been available for stakeholder comment, but now if you go on our website, if you're interested in this policy or any of the other ones, you can comment on them. Policy 10 we formalized it in 2006, and it deals with the producers of genetically engineered and cloned animals. A company came into being, Genetic Savings and Clone, offering the sale of cloned pets. Is that something that falls under the Animal Welfare Act regulations or not? Well, in consultation with our Office of General Counsel, we put this policy together, which called genetic engineering research. That's when we're still trying to answer a question, looking at what happens when you do different manipulations to the animals. But cloning is a different issue. Cloning may be a regulated sale, and it may not be, depending, kind of on a case-by-case basis. Just an aside, so you have a complete understanding of the Animal Welfare Act, agricultural animals are not and never have been included under the Act. Animals used for food or fiber are not included. So when we have a question like genetic engineering or cloning, and we're trying to make an interpretation, how do we decide? What do we use to make our decision? And I'd like to just leave you with a couple statements from the end of the first section of the Animal Welfare Act. These are policy statements on animal research, and this is Congress telling us how they're thinking about the use of animals in research. First, the use of animals is instrumental in advancing our knowledge of cures and treatments for diseases and injuries. The second point is that methods of testing that don't use animals can be faster and less expensive and even more accurate, better tests for some purposes, and we should really support further opportunities for the development of methods of testing that don't use animals. They go on to say that measures which eliminate or minimize unnecessary duplication of experiments on animals can result in more productive use of federal funds. There's only so much research funding to go around, and we want to make every dollar count, and every animal that we use, we want to make it count. And finally, measures that help meet the public concern for laboratory animal care and treatment are important in assuring that research will continue to progress. So with that, I hope you enjoy the rest of your conference. Thanks.
Just a reminder to turn your cell phones off. And if you have questions for the people speaking today, would you fill out a card and move them toward the front? We don't have a lot of time for Q&A, but we'll do what we can. And I think you'd answer questions later too, right?
Fine.
Okay, thank you. Welcome to Rachel Lattimore. She's from rural North Carolina. She has a background picking apples, birthing calves, and apparently winding cotton. She is a graduate of the University of North Carolina with distinction, and Victoria University in New Zealand with honors. So she has a lot of New Zealand connections, which David Faber, who's taught animal law in New Zealand, would appreciate. She is a graduate of this institution, Duke Law School. She is a partner in the prestigious law firm of Arndt Fox in Washington, D.C. She represents large and small technology providers, manufacturers of biological and chemical products, and nonprofits. And she knows everything about representing everybody in science. Welcome.
My mother write that? Oh, okay. Well, as an alum of Duke Law School, I'm thrilled to be back here speaking. It's much easier getting a parking space if you're a speaker than it ever was as a student. Since I graduated in 1994, the sounds of construction are very familiar to me, so I picked up on that right away. I was here when this place was much less fancy than it was now. So it's very exciting to see what some of the construction has brought about. As a 1994 grad, that really doesn't seem that long ago until I come back and feel older and older every time I come back. And this was really brought home to me last night when I was planning my remarks, and I realized I'm going to be talking about the regulation of a technology that's roughly the same age as I am. And I do use the term prehistory to describe it, so I think that makes me officially prehistoric, at least according to my 14-year-old niece. But I do want to put animal bioengineering in context. We've heard a great overview of the Animal Welfare Act. I was hearing all those Americans from the ABA this morning. That's all I could think of. The Animal Welfare Act. But there are certainly other laws that regulate this technology as well. And although this technology may be new to you, if you've been working on other issues through your career, or you just happen to wander in this classroom looking for your torts class, this may not be something you're familiar with, but certainly this is a technology that has its origins over the last 40 years, and certainly that the government has been looking into for some time now. And so I want to go through just the prehistory of federal regulation, a little bit about the history, and then give a very broad overview of the regulatory oversight that's in place today. So, as I say, in the late 60s and early 70s, the structure of DNA had been discovered, and scientists immediately started doing what scientists do, is poking at this new toy and seeing what they could do with it. And one of the things that they started doing was recombining bits of DNA from different species and seeing what would happen. This was a much more precise way of transferring genes than the old-fashioned way of sex, which, at least according to who my college roommates brought home, can be a completely random selection process. And this was more precise, but it was something that scientists hadn't been able to do before. And that naturally brought about some questions, some concerns among the scientists themselves. And so as they were working in this area, the scientific community called upon the National Academy of Sciences in 1973 to provide some guidance on the scientific issues, legal issues, bioethical issues associated with this new technology. And one of the recommendations from the 73 NAS report was to hold an international conference to address these issues. Not only the science and bioethical issues, but also issues of public perception. And so the historic Lattimore conference was held in 1975, which brought together some of the leading scientific minds from around the world to address these issues. One of the important really takeaways from the Lattimore conference was that while the technology was new, the potential risk involved in a particular experiment should be considered on a case-by-case basis, that any particular recombining of DNA could have specific effects. Some could be harmless, some could be of concern, and each experiment, each piece of research should be analyzed on its own merit. And so that was one of the primary messages from the Lattimore conference. One of the NIS's other major recommendations was that NIH, the National Institute of Health, which is a division of the Department of Health and Human Services, should form a committee to oversee this research. The scientific community at Asilomar also was in favor of not only strict self-regulation, but also this type of government oversight. So NIH did form such a committee and issued what was called the Guidelines for Research Involving Recombinant DNA Molecules. Those guidelines were published in 1976. They were made mandatory for any entity that was receiving federal funding, but those guidelines were also adopted voluntarily by the private sector. Those guidelines they were first updated in '78, and they are continually updated. Today, you can go on the NIH website and find them. And they continue to be universally adopted, both in a mandatory way for entities receiving federal funding and by the private sector as well. So this is going on all through the '70s. One of a primary push in research that we're going to hear more about over the next couple of days was a patent case that was issued by the U.S. Supreme Court in 1980, Diamond v. Chakrabarty. And in this case, the substance that a patent was sought for was bacteria that had been modified by recombinant DNA processes to produce a protein from another species. The court found that the bacteria now it had significantly different characteristics from those that the bacteria possessed in nature, and also the potential for significant utility. Essentially, in one of those great quotes from the Supreme Court, the court found that the inventor's discovery was not nature's handiwork, but his own. And so, as patents often do, this opened the doors for significant investment in this research. In addition to being something really cool, it now had the potential to make money for investors, and so this did increase research. So the NIH guidelines really spurred the federal government as a whole to consider its approach to the oversight of biotechnology. And this took the form of, in the early 80s, congressional attention to this, as well as attention by the federal agencies. And over a 2-year process, there were a series of public meetings, congressional hearings, and other agency activities that resulted in the 1986 release of, from the White House's Office of Science and Technology Policy, a coordinated framework for the development of biotechnology. It was intended as a comprehensive federal regulatory policy for ensuring the safety of biotechnology research and products. The fundamental principles of the coordinated framework were that new legislation wasn't needed, that we have the authority to regulate food, we have the authority to regulate drugs, we have the authority to regulate agriculture. The idea of having separate laws for these types of things that had been developed through a new technology seemed excessively duplicitous, even for Washington regulators, which is rare. But they did determine that new legislation wasn't necessary, but that a regulatory framework could be developed through those existing laws, and that as the technology developed over time, that regulatory framework may need to be tweaked to change from the regulation of bacterium to plants or to animals. And as the technology and its application developed, then the regulatory framework could change as well. An example of this is that USDA's regulations regarding plant biotechnology are in the process of being changed now. The three lead agencies that the coordinated framework identified to really have primary oversight over the new technology were the Federal Food and Drug Administration, the U.S. Department of Agriculture, and the Environmental Protection Agency. As I mentioned, those agencies deal food, drug, agriculture, the environment. Those were the areas that the government really saw as being primarily affected by this new technology. And so those were the agencies given the lead. I'm going to talk about each of those in turn and how they they have the authority to and are taking a look at the regulation of this technology. Oops. First, the Food and Drug Administration. The FDA acts under the authority of the Federal Food, Drug, and Cosmetic Act, regulating, not surprisingly, foods, drugs, cosmetics, among other things. But FDA defines new drugs as drugs that are intended to affect the structure or function of the body of man or other animals. So it's a very broad definition, and FDA has used that definition to assert its authority over transgenes in animals that have been bioengineered. So that if you're taking DNA from one animal, putting it in another animal, that new gene or the transgene is an object that is affecting the structure or function of that animal's body. And so FDA has asserted its jurisdiction over the transgene as a new animal drug. The Center for Veterinary Medicine within FDA has the authority over animal drugs. And CVM, in DC we love acronyms, CVM has stated that it intends to act as a gatekeeper for transgenic animals. Well, what does that mean? Not only will the transgene of these animals be of interest to FDA, but in many cases, the product that the animal might produce would also be subject to FDA oversight. If, for instance, the animal is a fish that has been bioengineered to grow faster, you're going to hear about that later on today. In that case, obviously food safety is an issue. And so the folks at FDA who deal with food safety are also going to be involved. In other examples, there may be animals that are being developed who produce therapeutic proteins in their blood or their milk. And in those cases, obviously, the therapeutics that might be used for animal or human use would also be subject to FDA oversight for those products. There may be animals that are being developed that would produce organs that could be more easily transplanted into humans. Those organs would be subject to FDA approval for their safety and their efficacy as the drug products or therapeutic products would be. So there are a lot of areas within FDA that may have oversight over particular animals. Again, the applications of the technology are still being developed, and as those move forward, then there'll be a better sense of who and how the appropriate regulation will take place. FDA is in the process of developing guidance on those very issues, how the parts of FDA will work together on a particular animal and particular animal product. And as I said, that final product may require separate regulatory approval or clearance. But FDA is not the only game in town. There are other government agencies that have an interest in this technology. The U.S. Department of Agriculture, USDA, we've heard this morning about APHIS, the Animal Plant and Health Inspection Service, the division within USDA that administers the Animal Welfare Act. And we've heard about how facilities conducting genetic engineering are regulated as research facilities under the AWA. APHIS also has taken the primary responsibility and is doing most of the research for transgenic insects. And as I've indicated here, APHIS has authority under the Plant Protection Act of 2000 and the Animal Health Protection Act of 2002 to protect plant and animal agriculture from pests and potential pests. If something needs to be studied until you figure out if it's a pest or not, then they have that authority as well. They also have authority to regulate biological control organisms. So USDA is doing research on things like the pink bollworm. And are there ways that the genetic structure of the pink bollworm could be manipulated to make it less pesky? That type of work is being done both through USDA's research facilities, but also under permit by APHIS. Those are strictly controlled. Under permit, those permits are processed with the availability for public input. FDA has not reached out to assert its drug authority over these insects. I don't want to speak for the agency, but I think they're happy to let USDA, with its long history of oversight against agricultural pests, letting them handle that. But if, for instance, a mosquito were developed that could administer malaria vaccines, certainly FDA would step in and be involved in that product development. The Environmental Protection Agency administers a number of environmental protection laws. One of the statutes that I find most interesting for having the most unpleasant actual title and yet the cutest acronym is the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA. And this is the statute under which FDA regulates pesticides and biological control agents. Now, as you may have noticed before, USDA regulates biological control organisms, whereas EPA regulates biological control agents. Again, only in Washington does this type of thing happen. FIFRA really kicks in when a product goes on the market. So if an insect is developed to perhaps attack another insect and is sold that way, then EPA may get involved to regulate that animal as a biological control agent. They could also regulate pesticidal products that are produced by animals. If an animal is developed to produce a protein that can be sold as a pesticide, EPA would regulate that. EPA also administers the Toxic Substance Control Act, or TSCA, which grants EPA broad authority over industrial chemicals, organic and inorganic, that aren't regulated by another federal agency. And this could regulate industrial products that may be produced by animals. There was research being done a few years ago on goats that had been bioengineered with genes from spiders to produce spider silk proteins in their milk. And so if that were determined by EPA to be a new chemical, then TSCA could apply. Another thing I want to make sure that we keep in mind is that any federal agency in making decisions, making policy decisions, taking significant actions, any federal agency in any area is subject to a couple overarching environmental protection statutes. NEPA, the National Environmental Policy Act, requires all federal agencies to assess the significant environmental impacts of the decisions they make. And similarly, the Endangered Species Act requires federal agency to consider the potential impact of a proposed action on threatened or endangered species and critical habitat. So certainly to the extent that a government agency is making a decision with regard to these animals that could have significant environmental impacts, these statutes would have to be considered. So I'm running out of time, and I know that some of these topics are going to be dealt with in greater detail over the next 2 days, but I hope that this has given you a good overview, and I hope that you find the next 2 days very helpful. Thank you.
This young woman is collecting questions, if you want to give any to her. Betty, the first question is for you. One of the students wanted clarification on the USDA's role with regard to the fact that rats, mice, and birds were left out of the Animal Welfare Act. Can you address that a little more? I think.
I think in later speakers you're going to hear a lot more details about this issue, right? But I can kind of tell you a little bit about how it works. When the department gets sued over some kind of interpretation, then it goes to the Department of Justice, and there's a lot of discussion about what the department's response is going to be to a lawsuit. So that's kind of one way that decisions get made about those sorts of issues, when the department gets sued and then there's a response. When Congress is looking into changing some of these interpretations or changing some of the regulations, then they hold hearings, and subject matter experts from animal care, from APHIS, represent the secretary in these committee meetings where, you know, they can ask any questions they want, and they have people from industry and advocacy groups come, and, you know, everybody gives their opinion. Whether I wasn't at that committee meeting, so somebody else might be able to tell you exactly how that went. But I do know that after a committee meeting like that, it's very common for Congress to come back to the department and ask us for facts, so that they can have this information to make good decisions. So that's where Animal Welfare Information Center comes in, and all the data that we collect on the number of animals that we have and the funding that we have and how many inspections an inspector can do, all that kind of information then goes back to Congress. So it's kind of, that's how the department interacts with Congress when they think about making those amendments. Did that answer your question? Okay.
Okay, this is a handwriting dilemma. Can you read this here? And if you can read it, Rachel, would you rephrase it and answer the question?
The question is...
We'll get you up to the mic. I see that you are, Mike, now that you can do whatever you want.
The question is, do infectious disease regulators keep an eye on these animals in light of the emergence of coronaviruses, for instance, SARS, avian flu, et cetera? I'm not familiar with the specific role of the infectious diseases folks within NIH or FDA being specifically following this. I think that it may be something that they would, that may come up during, I'm hearing from the expert that they are involved. Larissa, would you care to comment?
Yes, and once an investigational animal drug file is established, we're very concerned about the health of the animals. And so depending on the species, we will ask folks to monitor for and report to us on the presence of adventitious agents or diseases.
Excellent. That's Larissa Rodenko, who is the animal bioengineering expert within CVM at FDA. So thank you.
Wow, do we have a great program going. Back in 10 minutes, in your chairs.
I know you shortened it up to help us catch up, and I appreciate it.
Sure, no problem.